And here in Lagos State, the House of Assembly says it has no plans to scrap the 37 local council development areas in the state. Chairman of the House Committee on Local Government made this known during a one-day public hearing organized by the legislature. We have a report. Following the controversy surrounding the Supreme Court's judgment affirming financial autonomy of Nigeria's 774 local government areas and the recent move by the Lagos State House of Assembly to amend its local government administration law, reactions have trailed this development as there were notions that the Assembly may be gearing up to scrap the 37 LCDAs in the state on the grounds of the bill mooted by the lawmakers. This is the second public hearing held on the proposed local government administration law of the state, which the lawmakers noted is seeking to enhance how the third tier of government should be administered.
It should be noted that due to the recent judgment of the Supreme Court granting autonomy to the 774 local governments in the nation, the House of Assembly is obligated to abide and act in accordance with the Supreme Court judgments.
Seated are traditional rulers, legal luminaries, civil society organizations and other members of public, all eager to share their thoughts on the proposed law.
We should be very careful in whatever amendment that we are doing. Any amendment in any way that affects that autonomy should no way be talked about at all. Just give them their resources. Let them go and implement their resources. Let their councillors hold them accountable.
Then you look at proposed section 30, where it is said that the House of Assembly can suspend. The House of Assembly cannot suspend. He's an elected person. But assuming without considering that the House of Assembly can make intervention, there must be some condition precedent. Maybe after the members of the council have taken their position, then as a supervisory authority, the House can now say, okay, bring the matter to us, let us see. But to say that the House can of its own say, oh yeah, Chairman, come and account to us, I don't think it is right. When we look at the proposed section 3(2), it says local government chairman shall be elected. With all respect, everything with the SCDA dies with that provision.
Reacting to the bill, which contains 60 clauses, a Lagos-based lawyer, Muiz Banre, faulted some clauses in the bill, stating that the state governor has no power over council chairmen if they misbehave, which was immediately countered by a former lawmaker.
The funding by the Constitution today and the Supreme Court judgment, they are saying that the only person that can deal with the fund of a local government in accordance with the law, that is in the manner deemed fit, is as between the chairman and vice chairman of the council and his ESCO and the councillors. Now again, if you look at subsection 4 of the same section that I said, that it can assign duty signed by the House, by any law of the House or executive directive of the governor. Again, this is very offensive of that decision of the Supreme Court. The import of the Supreme Court decision is simple. The state, the governor cannot do anything as regards their responsibilities and their duties. And it is said in that judgment, we look at it, that even where they misbehave, it is their council that can discipline them.
And we are saying House doesn't have power to do so many things again. I know that the present Supreme Court judgment is only about finances. And it doesn't remove all other one. The existence, the establishment of local government still resides with the state. Therefore, we need to be very careful.
All CDAs is particularly the reason we are here. We don't want all CDAs to die.
The continued existence of the 37 LCDAs in the state, which has remained the bone of contention, was thoroughly addressed.
Nobody is killing the LCDA. We need to get that clear. Nobody is killing the LCDA. It is the creation and legacy of our leader. And we are going to make sure it does not die. So at this point, it is a call for every Lagosian to rise up and protect these LCDAs. by reaching out to all our representatives at the national level.
What we have to look at is, let's not confuse that judgment, which is very clear on a particular issue of financial autonomy, with other things like creation of local government. I think once we appreciate the fact that one Supreme Court judgment is talking about the creation of the local additional 37 being incoherent, and one other Supreme Court judgment is talking about the financial autonomy of the local government. We shouldn't mix them together.
The pronouncement of the Justice of the Supreme Court is clear enough. It has handed over the financial autonomy to the local government. And because we also have a responsibility as an House of Assembly, as empowered by the Constitution, Section 7(1), we must adjust our law to reflect the pronouncement of the Justice of the Supreme Court.
The lawmakers assured that every concerns raised and contributions made will be